Hi, I'm attorney Jason T. Brown, head of the whistleblower law firm Brown LLC. I'm also a former special agent and legal advisor with the FBI, and we have other Department of Justice alumni here at the firm. I want to speak with you a little bit about SEC Whistleblower Program, particularly what it means, not just its upside in terms of its magnificent awards to individuals who are on the inside who blow the whistle, but something where I want you to think about it as a proactive defense. If you are a well-placed insider and you know about a securities violation in a publicly traded company, you run the risk one day of being the target of an investigation. If you have information, you're not sharing it, you're not cooperating with the authorities, you run the risk that someday the authorities are going to come knocking and view you as part of the problem rather than part of the solution. You need to speak with an SEC whistleblower law firm early to understand what your rights and options are. There's a tremendous upside. Hundreds of millions of dollars have gone to whistleblowers who blew the whistle the proper way with a TCR in the SEC Whistleblower Program. Also, with the use of an SEC whistleblower law firm, the individual potentially could remain anonymous even to the government from start to finish. So you may say, Jason, isn't that a bit incongruent? How can this protect me? Well, if the hammer comes down, and it comes down hard on the company, and the SEC will hammer the companies pretty hard, generally and typically, it'll be just a fine, no matter how uncomfortable it may seem when you're going through the process. But sometimes there's the criminal element. Look at the movie Wolf of Wall Street, about what went on there. And you can build potentially a proactive defense by having that little chip, knowing that you were the one who initially alerted the authorities to what the problem is. Yes, it's complicated. Yes, it's elegant. So that's why when your career's on the line and a lot of money's on the line, you need advice that you could rely on. You need to speak with a firm that has a niche of protecting whistleblowers like Brown LLC. Let me talk you through certain fact patterns that the SEC is presently on the lookout for. Number one, falsification of earnings. Now, that could come a couple ways. Number one, just cooking the books, just outright misstating the earnings. That's more rare, but it's not completely unheard of nowadays, but it could happen. What typically happens is leading up to earnings, rather than an outright falsification, there's bluster. And what is bluster? Bluster is the puffery of information to lead investors to believe the company is doing better than it is. For example, a publicly traded company may say it is in talks with a major company for it to buy $100 million of its product. Now, if that is truthful, great. You may be able to get away with that statement. But if you know the talks have already fizzled and you've released information to that effect in order to marshal a stock price that goes up, you may have very well committed an SEC infraction. And companies sometimes skirt the line about what it can and cannot do. So if a company is telling the public one thing and privately knows something else, that a lot of time will be the foundation and predicate for an SEC charge. Remember, the SEC wants to make sure that the interests of the investors are not subordinate to the interests of the company. So basically, the interests of the investors have to take precedent. If the company is doing things or taking actions that enrich itself at the expense of its client base, at the expense of the investors, that's predicate grounds for the SEC to come in and take action. Some things you know and I know are outright illegal. Ponzi schemes. How does it still happen? It still does, right? We look at Sam Bankman-Fried, just went to jail with all his scams and fraud, even though he's on appeal and claims he's innocent. He's guilty. He's found guilty. How did that persist? It wouldn't have If insiders close to him had blown the whistle early, potentially it could have saved a lot of investor loss. It could have protected the integrity of the markets, and the individual could have been handsomely rewarded for their information. When billions are in play, whistleblowers can receive up to 30% under the SEC Whistleblower Program. Another example, Celsius, another robbing Peter to pay Paul, another Ponzi scheme, allegedly, that's going through a bankruptcy. Early insider could have quashed that and really helped with the heartache to a lot of what the investors have felt and are still feeling as a result of that meltdown. Other areas that the SEC are looking for: market manipulation. That goes a little bit in concert with false press releases, puffery. But when the entity is doing things in order to artificially jack up the price or depress the price and taking the position where it's profiting from the action, that's a big no-no. Accounting fraud. Some elegant ways to keep the books perhaps seem legitimate, particularly if armed with an arsenal of accountants that are former IRS. But some you just intuitively, are just wrong. Double counting, falsification, illegal deductions, complicated tax schemes with tax havens that the IRS has already found to be illegitimate, taking steps in order to secrete where the assets are. Look what happened with the UBS scandal all those years ago, in which the whistleblower received hundreds of millions of dollars for what U.S. people were thought had a tax shelter when in fact it wasn't. Yes, it implicates IRS programs, but it also implicates SEC programs when financial entities are involved in secreting wealth, so it evades detection. Evading detection itself can be something actionable by the SEC. In 2023, last year, it dinged companies for hundreds of millions of dollars who were having their paper trails disappear. And nowadays, paper is not really the right term. Their electronic trail. When they were having backdoor communications with their client base, when they were not preserving their WhatsApp and WeChat conversations, the SEC is very interested in, number one, is the company aware that these communications are happening between advisors and the constituency? And number two, are they not being preserved? And what's the company's position on making sure there's the preservation of the electronic trail, and is that enforced? So that could be a action all by itself. Another thing is thwarting the SEC. If there's agreements made with top-level people and even people on the way out, instead of actively encouraging or making sure that there's no prohibition about cooperation with the regulatory authorities, if there is language in those agreements that deliberately thwart the ability of the government to access key players, the company is going to be in trouble. The SEC will take action on that. A big issue is FCPA, Foreign Corrupt Practices Act, the bribery in order to obtain business. It happens more often than you think in foreign countries. There's some ambiguity about what's covered through the SEC program, what may be covered by the new DOJ program, and what might not be covered at all. But if you know about a bribe that took place, there may be criminal implications as well as civil. So it's best to sort that out early to figure out what bucket that falls into and what could be done with that particular piece of information. If the company does misleading or incomplete disclosures, well, once again, that's for the benefit of the company and to the detriment of the investor, and thereby it's something that the SEC might be interested in. From all these things I've mentioned, we've heard a theme, and that consistent theme is you have to do right by the investor, not by the company itself. You cannot put the company's interests ahead of that of the investor. And if you keep that general rule in mind and you think to yourself, if somebody's viewing this in retrospect, who do they think's interest we were advancing by taking the action? Just by remembering that cardinal rule, you could come up to the conclusion yourself probably whether the company's doing something correct or illegal. Sometimes it's subtle. If it's subtle, it may not be actionable, but don't you want to know that? P.S. Again, this is not just the civil realm you're playing with. you are playing with potential criminal liability and criminal implications, which underscores what we talked about at the very beginning of this, which is it is critical. If you are a well-placed insider, it's not just the upside of potentially obtaining hundreds of millions of dollars in SEC whistleblower awards. It's the downside about your reputation, your potential criminal liability, and what you're going to do moving forward. So if you have this information, you need to speak with a whistleblower law firm. I strongly encourage you to call our firm, 877-561-0000. But even if it's not the really nimble, well-accomplished whistleblower law firm of Brown LLC, I encourage you to call a firm that has a focus of its practice on protecting whistleblowers and actually has done so. And I'll put that to the test because I think there's maybe only a handful of firms that are as accomplished as Brown LLC has been in this space. Think before you act. We offer free confidential consultations. Even in person, we have a secreted office in Wall Street West, which is on the other side of the Hudson, outside of New York. That way, people won't see you coming to the office, or we can meet at a neutral third-party location if needed. We'll certainly speak to you on the phone and figure out what, if anything, we can do for you. This video was for insiders, individuals who are on the inside of organizations that have this information, that are jammed up, they don't know where to turn to. Know that you can always confidentially speak with an attorney who can tell you what your rights are. And instead of every night not going to bed because you're worried about something bad happening, at least know what the potential implications are of the information, how to potentially monetize it, and better yet, how to potentially protect yourself. Because with the SEC Whistleblower Law Firm, you can remain anonymous and you can also have a chip for protection. So please, if you have information, take the time, make the call. It'll be worth it.